Well, this is the NYU equivalent of the presidential debates, and I am not Ryan Goodman, who could not make it at the last minute, so I'm stuck with this. This is Jose Alvarez, and I'm going to give you what she deserved at the beginning, which is an introduction to Beth Simmons. She's Clarence Dillon Professor of International Affairs and Director of the Weatherhead Center for International Affairs at Harvard University. She received her PhD from Harvard University in the Department of Government, and she's taught international relations, international law, and international political economy at Duke, University of California at Berkeley, and of course at Harvard. Her book, Who Adjusts? Domestic Sources of Foreign Economic Policy During the Interwar Years, 1924-1939, was recognized by the American Political Science Association in 1995 as the best book published in 1994 in government, politics, or international relations. The same happened with her recent book, the one we've been discussing, Mobilizing for Human Rights, International Law and Domestic Politics, 2009. That won the Best Book Awards from the American Society for International Law, the American Social Science Council. She was elected to the American Academy of Arts and Sciences in 2009 and was recently a fellow at the Strauss Institute for the Advanced Study of Law and Justice at New York University, and is the current president of the International Studies Association. Her current areas of research are foreign direct investment law, international legal cooperation to address transnational crime, and the diffusion of human rights through international and domestic law and politics. And I will go ahead and introduce Eric Posner, since, as you know, this is going to be a debate format, so the way the debaters have worked this out with their respective presidential advisors is that Beth will be permitted 15 minutes to say a few words in response to everything else that's been said throughout the day. And then Professor Posner will come back with 15 minutes of criticisms of what Beth has to say in her book. And then Beth gets a response time. And hopefully we will still have time for Q&A, but that's my responsibility, not theirs. So Eric Posner is the Kirkland and Ellis Professor of Law at the University of Chicago. He writes about contract law, international law, constitutional law, and administrative law. His books include Economic Foundations of International Law with Alan Sykes, which is forthcoming, Contract Law and Theory, also forthcoming, The Executive Unbound After the Madisonian Republic with Adrian Vermeule, Climate Change Justice with David Westbach, The Perils of Global Legalism from 2009, Terror in the Balance, Security, Liberty, and the Courts, again with Adrian Vermeule, New Foundations of Cost-Benefit Analysis with Matthew Adler, The Limits of International Law with Jack Goldsmith, Law and Social Norms, the Chicago Lectures in Law and Economics, he was the editor of that, and the Cost-Benefit Analysis, Legal, Economic, and Philosophical Perspectives, he's the editor with Matthew Adler. He's also a fellow of the American Academy of Arts and Sciences. So with that, Beth, it's your turn.
Well, thank you very much for this wonderful event. I have been having a very nice day. Thank you very much. I do have a feeling it's just about over, however. So I'm going to enjoy the last few moments while it is possible to do that. I thought what I might do is to just begin with a little bit about why I wrote the book and who it was written for. You know, who got me interested in this question of whether treaties matter for human rights and for international law generally were my students. So I teach international law to undergraduate students, and you know, a couple weeks into the course, it's like, Professor Simmons, why does any of this matter? And when I was teaching this a decade ago, we just didn't have good answers to that kind of a question. There was no empirical work, you know, or actually I started teaching probably 2 decades ago. There was no good empirical work that really addressed the extent to which international law and treaties could matter and could affect outcomes and consequences that we're interested in. And so I wrote a book, and I think it's a book that lawyers would like the message, but not especially like the methods. And political scientists would like the methods, but not really be enamored too much of the message, especially realist international relations scholars. And so I was afraid the book, therefore, would sort of just fall into this black hole between law on the one hand and political science on the other. And I've been really glad to have appreciative audiences, basically, from multiple disciplines. So that's been very gratifying indeed. Just a little bit about how the book is organized, because you might get the sense it's all about torture It is not all about torture. It really has a chapter that talks a little bit why we get the creation of an international human rights regime at all mid-century. And so it does contextualize the legal issues, the legal regime, in a broader sweep of history, a political history, quite obviously legal history, and the history of international civil society as well. So to understand that context, I think, is quite important. And then I ask, why do states ratify these regimes, which for them, we're not designed for them in particular, that they have to accede or not, ratify or not, based on a whole set of compromises, many of which they might not have been interested in making, so no treaty is perfect. And the answer I give is not exactly that states make mistakes. This is not quite my answer to this question, that they take rational decisions about ratifying these treaties. For repressive regimes, often they are trying to reduce criticism, and I found very interesting evidence that states emulate each other in their ratification behavior. So that if you are one of the states in a region, one of the few that hasn't ratified yet, there's a strong tendency to ratify given the density of ratifications around you. And so I argue, and take a pretty close look at that, argue these aren't mistakes. These aren't mistakes. These are rational calculations that, that you can avoid criticism given by governments that have short time horizons, quite often, and given a very poor information environment. So they take these kinds of risks and gambles when they don't think they're going to be caught. And so it's a calculation in that sense. So it's not exactly just merely making mistakes, and all of these things can be documented with the statistical evidence. Then I talk about the treaty effects. And I argue basically that you do not get enforcement with these treaties internationally. I have a feeling that Eric and I will agree on this point. And I want to push back a little bit against the analogy of trade. States are not likely to enforce these agreements against other states. I imagine that Eric is going to agree with that point for the most part as well. This doesn't mean that we all should conclude that these treaties are useless. And so I look elsewhere, somewhere else, for the enforcement of international human rights treaties. And so I argue that this enforcement is indeed likely to be at the domestic level. If they get enforced, it is likely to be because there are actors that have a very strong stake, a very personal, a very clear stake in what's going on with these issue areas and in these rights areas that they will press, they will demand for a certain amount of pressure and present pressure on governments to comply with their ratification decisions. It puts a new agenda on the table domestically. It introduces an issue that many states would not have been bringing up at that point in time, perhaps later, but not at the point in time when the ratification decision is discussed. It increases the strength of domestic demands and potentially increases the case that can be made because they are available for litigation. They may not be the ideal instrument for litigation, but they add to the kind of ammunition that can be brought in a court case. And most importantly, I think, the thing that I really try to focus on in this book is that they strengthen the demands domestically political. The political role of these treaties is really the one that I wanted to highlight in this book. The extent to which they have their most significant effects, where people have both the motive and the means, both, to mobilize, to take advantage of the provisions in the treaties to press their governments for change. And the argument is that this does not happen in stable autocracies, where they will be crushed, so they don't really have the means to use the treaty effectively in a political sense. And it doesn't happen very often in democratic countries either, where there is no motive because we enjoy such a wide variety of rights already, that the motivation to mobilize, to demand that a particular aspect of a treaty be respected, we got other things to do, and we're not out there on the streets demanding that kind of activity. So it is in the transitional countries precisely where you get both the motive and the means. And that is the nature of the argument that you've been hearing about, the transitional countries. And the definition I use of transitional countries is not a country transitioning positively necessarily, although they are included, but any country that is not stably autocratic, or stably democratic since the Second World War. It's a huge collection of countries. It numbers about 75 to 80 countries, and it's, I would argue, a pretty important sector of the globally of the number of states. The main findings, I think I should probably summarize very quickly. There is a chapter on civil and political rights where I look at the freedom of religion, fair trials, and the death penalty. There is a chapter on women's rights where I look at the ratio of girls to boys in elementary school, arguing that the Convention on the Elimination of Discrimination Against Women at a minimum should encourage governments to give girls the opportunity to get the education as is guaranteed or promised in that treaty. I look at the ratio of women to men in public employment. Public employment, because if we're talking about governments living up to their promises, that's where we should see the effects of this treaty in the first instance. And then I look at women's access to modern forms of birth control as well. And it sounds like it sounds like that probably all I do is statistics, but I try to illustrate all of the mechanisms because the picture that was put up about treaty outcome, ratification outcome in the big circle, I think the circle even expanded dramatically, saying where is the discussion, that link? It's in the case studies. You can see the strategies working out in the case study and the very conscious effort of actors with an interest, local actors, with an interest in the outcomes associated with this treaty, to use them in very strategic ways to try to make their points. And so I used two case studies in that case, the case of employment in Japan and the case of access to modern forms of birth control in Colombia. Chapter 7 is the torture chapter. I used the torture scale that you have seen up here. And let me tell you, those results are the weakest results in the book. It is hard to document a direct effect from a treaty to a torture outcome. And the reason, I think, is what has already been discussed in this room. Torture is very, very difficult to monitor. It's not centralized. Governments usually deny it. Peter, they usually do. And so the argument basically is that it's a hidden activity, very, very difficult to see whether there's compliance or not. And that contrasts with some of the findings I found in other areas. Chapter 8 deals with children's rights. It looks at child soldiers, laws, and observations by NGOs of the prevalence of child soldiers, child labor, and child immunizations. And each of these chapters have some highly suggestive, let me just use the word highly suggestive, and let me stress the word evidence, not the word proof. I know proof is a word that legal scholars will put a lot more stock in than just evidence. But as a social scientist, the word proof is not even in my vocabulary. Oh, well, I guess it is in formal modelers' vocabularies. But it is not in my vocabulary, the word proof. I can only present you suggestive evidence and try to indicate a logical, reasonable argument that would link the association that we're seeing in the statistics with some kind of a causal story. Okay, so what important findings do I think I came across here? Treaties affect different countries differently. This should be no surprise to anybody in the room. This should be no surprise at all, but political scientists started out in this area by just running regressions across all countries. And so the concentrated effects really are in this large group of countries that are neither stably democratic nor stably autocratic during this time period. I found, for example, that fair trials and torture really only worked in transition countries. Those treaties only affected outcomes in transition countries. Interestingly, with women's rights, there is no effect to these treaties in countries where you have an established religion, a state-sponsored religion. And it is the Catholic and the Islamic countries that account for that. But it is, and not the Protestant countries, for example, so it doesn't apply to Scandinavia. So what I'm trying to argue is that, we can argue transition, autocratic, what have you, but the important thing is where you live in a setting in which you are so likely to be crushed if you try to demand or poo-pooed or ostracized by making your demands for your rights. These treaties are not magic. They don't overcome that kind of opposition. It's where you have the motive and the means to use the treaty strategically and in a persuasive kind of a way in which these treaties end up having much more impact. Let me be very clear about what I'm not claiming. Treaties are not magic bullets. If there is one thing I want people to take away from this book, it is not that Beth Simmons believes that all we need to do is run around the world and get all states to ratify all treaties and human rights will eventually improve. That is not the message of the book. They're not magic bullets. I show no evidence they work in extraordinarily hostile environments. So it's really important to keep that in perspective. The second thing is, they are not the only thing that matter. And so if you really want to affect human rights, you will solve war, you will make every country democratic, and you will raise every country's developmental level. Now, these are the mega projects that we've been working on for decades now. Nobody's got a great solution to those. So my argument is international law should be a tool that we can use to influence rights, given that we can't stop war in any automatic kind of way, and we can't. We have found no way yet to solve these mega projects. But this is not a substitute for trying. Okay, so not a substitute policy for addressing very serious issues that affect human rights. They are not a substitute for peacemaking, for democratization support, and for developmental programs. Let me just a couple of moments, if I may, to just answer a couple of other questions that have come up along the way. This question of the role of the domestic and the international. Let me stress, and to sort of echo something that Catherine said with respect, she talked about the using of sort of cherry picking from international treaties to help to make domestic cases. Actually, one interesting thing that we're finding, I'm doing a little bit of empirical work with Tom Ginsberg and Zach Elkins, looking at the relationship between treaties and constitutions. We find after a treaty is open for signature, that there is actually a big increase in the number of new constitutions that absorb those rights. So interesting that these are not either or. The treaties influence the constitutions. The treaties influence the domestic statutes. And either or, I take both. I'll use whatever instrument that I find useful, and there is a lot of reasons to think, in a lot of cases, that they are mutually reinforced. In fact, think about this. Wouldn't it hurt your credibility to put it in your constitution and not ratify? Wouldn't it hurt your credibility to ratify and not put it in your constitution? So if a state wants to send the most credible sort of signal possible, they will do both. They will do both. And it seems to me that these are not substitute policies. What are the distinctive features of international, why didn't I pay more attention to international non-governmental organizations? The only reason, let me tell you honestly, the only reason I did is that when I started this book, that was the traditional story, that it was all about non-governmental organizations. And I think, and I still do think, that there is a tendency to credit foreigners with change in a lot of these countries. There's a sense in which a lot of times the story is, the NGOs kind of swoop in from the outside and bring light and bring enlightenment and that kind of thing, and press for change, and the folks on the ground sometimes, in some accounts, are actually presented as rather passive agents. And I really wanted to counter that, and I really wanted to emphasize the story about the people on the ground, emphasize through the case studies, locals, that take the available transnational norms and use them domestically. And so I think that the traditional story underemphasized the role of domestic actors, which I think have been portrayed just a little bit passively compared to the transnational actors that many people like to point to. And I really wanted to kind of fill that gap in particular. Why treaties? Why law? I don't know. Why do we need law instead of other kinds of norms? It seems to me, that law does have some kind of legitimacy that stressing a norm in a non-legal way seems to have. And I know that's strange, sort of coming from the mouth of a political scientist, perhaps. But, we've actually started to do a little bit of research into this area and done some experiments that involve giving some information about torture and then giving some members of a surveyed group the added information that there is a treaty that requires this behavior, and then the other half doesn't get that information. And to look at that shift in the change, I was going to show you something, but the thing went off and it's not on anymore. I did this test just in Colombia 2 weeks ago. And in terms of torture, to tell Colombians that there is a treaty compared to that their country hasn't signed a treaty, it shifts the increase in the percentage of opinion away from the idea that torture is appropriate in some circumstances extremely significantly. And so what I'm trying to say is telling people that there is a legal principle involved or a legal commitment. We're starting to do a little bit of work in this area, and it's sort of getting now to the psychological almost. What is it that makes people sort of more seriously think hard about the constraints on behavior? So that kind of work is increasingly being done. And then finally, I just want to say a couple of things about the sources of data really quickly. The data in the book are all of the things that Phil Alston talked about. They are self-reported. And always the self-reported is more likely to be the most optimistic. So you have to be the most careful with self-reported data. There is government-reported data. So U.S. State Department and Amnesty International, non-governmental organization data in the book from Amnesty International, and then scholarly data, so data put together by Singranelli and Richards and others. Let me just tell you what my rules are for using data. Number one, be skeptical. Be statistically skeptical. So if you think there are trends in the data, take care of that. And number two, take as many different takes on the data that you can. Use different data sets, do different specifications, be comparative. Compare different measures as much as you can, and see whether the results you get are dependent on using one source compared to another. Most importantly, more importantly than anything else for a social scientist, be transparent. This means we exactly explain how we code things. This means we post our data. If people find mistakes, they inform us, and over time, the data get better. Just very quickly to this idea of democratizing data. There actually are already ways to do this. So I don't know if any of you have heard about these sort of platforms that individuals can participate with called, that try to report human rights abuses. And actually they've been used in Kenya. About 45,000 people called in abuses in the post-election violence in Kenya using this platform called Ushahidi, which means witness. And then, potentially one could imagine a platform like this being a possibility for democratizing. Now, I am skeptical a little bit, especially like when you ask people to report species sightings and that kinds of things. They confuse jaguars for Labrador retrievers and all kinds of stuff like this. So it's, you got to worry. You've got to worry about democratizing data. So basically, I just want to wrap up by saying that I appreciate the comments, especially those comments that see it as a cautious work, because I do think that in many ways I've probably underestimated the extent to which international law matters for the practice of human rights globally. I'm pretty sure I've underestimated because I'm not really looking at its sort of broader impacts that you cannot measure. I'm not really looking at the way that it's mediated through many other different kinds of institutions. And in fact, you know what? I think today we would even have a hard time with the counterfactual of what this world would look like if there were no international legal structure for addressing human rights. Can we even imagine what that would look like? It's hard. It's hard. And I think that alone is an attestation to how important the human rights legal regime has been in the world.
I'll stay there. Let me start by thanking the students for inviting me to undertake my customary role as Darth Vader. Now, I'm a little worried that there may be some false advertising here. You came here expecting blood to fly and all the other attributes of a debate, but I like this book a when I started writing about international law, one of my complaints was that people hadn't thought about international law in a sufficiently empirically rigorous way, and so I can't show ingratitude now and complain that Beth has done just this and come to results that maybe I don't like, maybe I do like. I'm not sure. What I'm going to do though is I'm going to provide a commentary on the book. I'm not going to use this as a platform for reasserting my own views, although I'm sure they'll leak out to some extent. But the book is extremely rich. It raises a huge number of questions. I don't have that much time, so I'm going to be selective. But what I would like to do is cover the three main elements of the book: the theory, the empirical method and results, and then a little bit on the normative implications. And maybe at that point I'll put on my Darth Vader hat. But in the meantime, I'm going to express my criticisms more as questions. I am actually not an empiricist myself, so I'm at some disadvantage. Some of Beth's claims I don't understand fully, so I'll put those as questions. So first of all, theory. Why do states enter human rights treaties? That's the first question Beth asks. She proposes a theory of rationally expressive commitment, as she calls it. She says governments are more likely to ratify rights treaties they believe in and with which they can comply at a reasonable cost than those they oppose or find threatening. I'm quoting. And she just mentions, she mentioned maybe just now or in the book that she thinks that governments will enter human rights treaties when the treaties reflect the government's own preferences. And then the puzzle is, well, then why don't all liberal democracies enter human rights treaties while all authoritarian states do not? And she provides a number of reasons. I just want to say about this that one puzzle that's raised by her theory, and I think this was mentioned earlier today, is it doesn't actually explain why a government would enter a human rights treaty. She doesn't explain what the benefit is. So let me give you an analogy. So as it turns out, this might surprise some of you, but I don't actually like torturing animals. But I have a pet cat, or I did at least. He died recently, but not of my hand. And yet, one could imagine I might enter into a contract of some sort with another person who likes his pet, and we would agree we're not going to torture our pets. Now, why would we do this? The contract reflects our views, but it's costly to go through the trouble, And of course, Beth stresses the costs that states face in entering into treaties. So what's the benefit for us from entering into this strange contract? So I think this is actually puzzling, and my suspicion is that Beth thinks that there actually, even though she denies this, she thinks that there are external benefits from states for doing this. But I'll get back to that when we talk about the empirical stuff. Now I want to pause here and mention a little bit about, speak a little bit about the common law, which plays an important role in Beth's book in two ways. First of all, related to what I was just talking about, when she tries to explain why some liberal democracies don't enter into human rights treaties or don't enter into all human rights treaties, she cites the common law as a reason. And then it also plays a role as an instrumental variable in her regressions, in many of her regressions, I think. Not all of them, but many of them. And and it is true, when lots of cross-country regressions produced by lots of people, the common law just pops up all the time. And it's kind of a puzzle. Beth gives a number of reasons why she thinks that the common law presents a cost for states. So in this context, her view is that liberal democracies that have common law systems will find it more costly to enter into treaties, and she gives a number of reasons. One of the reasons is that in common law countries, judges tend to have more independence than judges in civil law, or I'm just going to say civil law rather than non-common law states. That may be true. I don't know whether that's true, but if it's true, it seems to me it would be better simply to use judicial independence as the variable. There's data on judicial independence that people have been collecting. I don't think it's always true. It may be true as a general matter. Then she says that she thinks that treaties are, she says, quote, more of a foreign substance, unquote, in a common law system than in a civil law system. Again, I'm not exactly sure what she means by that. You need to remember that U.S. federal courts have very limited common law powers. You might not even call them common law courts at all. Further, common law systems are filled with codes, statutes, which are just like treaties. And judges understand how these codes work. There's no particular reason to think that judges would find anything foreign about treaties. In fact, the United States, which is the largest country with a common law system, I suppose, I think, the U.S. is party to more treaties than any other country in the world. And so judges confront treaties all the time. She says that common law judges must undergo an attitude adjustment that civil law judges don't need to undergo, but why would we think this is the case when common law countries have so many treaties and have had them, of course, in their systems for hundreds of years? She says that common law judges, in common law systems, it's more uncertain how courts will interpret treaties than in civil law systems. Again, I'm not sure that that's true. My view is that in common law systems, judicial behavior is actually more predictable than in civil law systems because judges give reasons, and you can make predictions about their future behavior by looking at their opinions. And then finally, she says that in a common law system, treaties are irreversible. I didn't understand that. You can reverse a treaty in any system except, I suppose, a system where treaties are constitutionalized. Even then, you can reverse them with an amendment. She mentions lifetime tenure, but that doesn't lead to a clear prediction about how judges will behave. Judges with lifetime tenure might be more independent. That might make them enthusiastic about enforcing treaties, which may make it more costly for the country to enter the treaty, but it might make them skeptical about treaties, and you can't stop them if they have independence. Okay, second argument in the theory section of the book, why do states comply with human rights treaties? And Beth basically has, as people have discussed, mentions three mechanisms: the agenda setting mechanism, the litigation mechanism, and the mobilization mechanism. Let me say again a few words about each of these theories. They're all, I want to emphasize, they're all sort of complicated ideas that really need more time than I can give them. But this agenda setting idea, of course, for some countries, the ones that propose the treaties, they're not passive recipients. She's talking about the other countries for whom it may be the case a treaty is an exogenous event. And if I understand her argument, she says that it's sort of hard for the government officials, once the treaty has been proposed, to say no, or it's harder for them to say no about a ban on torture than it would be if the treaty is never proposed in the first place. Notice the influence of outsiders here. The outsiders set the agenda for the state, and so presumably they have a certain amount of influence. But putting that aside, I just don't understand the theory. Anybody in a state can set the agenda. A dissident, a famous person, groups within the country, unless it's a totalitarian state, they can all say to the government, hey, how about a ban on torture? And the government has to say no if it doesn't want to do that. It's not clear to me what's distinctive about the treaty. Second mechanism, litigation. So this seems to me a little bit question-begging. The problem here is that when a state enters into a treaty, litigation doesn't follow as a matter of course. Okay, so there are different types of states. If you're in a dualist state, or even in a monist state, frequently what happens is that there has to be two acts. First, the treaty is ratified, and then the government has to take another positive act to give people judicially enforceable rights under the treaty. They don't have to do that, okay? And even in monist states, you can opt out of domestic enforcement of treaties. And in some states, the judges are only supposed to enforce treaties if the treaties are being enforced in other states as well. So the question then is, the compliance question just gets moved back a step. The question is, all right, you've got all this litigation, maybe that'll constrain the state, but then the question is, why does the state comply by making it possible for people to engage in litigation? And then on the third argument about mobilization, Beth's argument is that people are more likely to mobilize if they think it's more likely that they'll succeed. And if the government has said, okay, we ban torture, that suggests maybe there's some people in the government enters into the Convention Against Torture. Maybe that means that there's some people in the government who are opposed to torture, and so there's a higher expected payoff from mobilizing. But it's just, seems a little odd. Why does there have to be a treaty there? I mean, if there are people already in the government who don't like torture, you'd think that the people in civil society would know it. You'd think the people in the government might propose statutes that are turned down. I mean, after all, we're assuming they have enough influence to ensure that the treaty is ratified. You'd think they'd have enough influence to propose a statute or even get a statute enacted. So the mobilization theory puzzles me a little bit as well. Okay, so much for theory. Let me go on to the empirics. And this, of course, is the heart of the book. Let me mention a few points. Okay, so first of all, Beth has these graphs throughout the book, right? As those of you who've read the book. Okay, so these graphs, and I wish I had a blackboard or something, but they all look the same except for the death penalty graph. In all of these graphs, on the y-axis, the horizontal axis, you have the year, and on the x-axis, you have a number. Okay, so you could have number of treaties, or the number of, or the human right outcome. Lower number means worse human right outcome, more torture. High number means better human right outcome. All of these graphs look the same. That is, the human right outcome, what we care about, the amount of torture or what have you, is pretty much flat. Okay? Sometimes it goes down a little bit, sometimes it goes up a little bit. Meaning that over the last 30 years or so, states collectively haven't really gotten much better, or maybe just a little bit better. Okay, so that's one line. The other line are the treaties, okay? The number of states that have ratified the relevant treaty. That is a steeply sloped, upward sloping line, right? It starts at 0 and it zooms up, okay? There's no correlation between these two lines, okay? Which is, I think why, sort of in a formal way, why people tend to be skeptical, or at least some people tend to be skeptical about whether these human rights treaties make a difference in the first place. Okay, now, of course, Beth finds results, statistically significant results, because for the most part, she's not looking at all of the states and all of the treaties. She divides the states up into a bit. But I think at least these graphs should make you feel a certain amount of skepticism about whether human rights treaties actually improve human rights outcome. Now, I'm going to come back to this point about dividing populations up in a moment. But there's another point, which is this point about compliance. Beth is very careful about this. She's not proving that states comply, she's not providing evidence that states comply with treaties. She's just trying to show that they have some kind of causal effect. Now, this is a crucial point for understanding various debates that people have had, both in mainly I would say in the legal literature, but also in the political science literature. What does it mean to say that there's a causal effect but no compliance? Well, let me give you an analogy. Imagine a state enters into a treaty like a sovereign debt contract. We're going to borrow $10 million and we'll pay you back in 5 years. So they borrow the $10 million, and then 5 years later they pay back $1 million. Okay? And we'll suppose further that if it hadn't been for the treaty, they would have paid back 0. Okay, so here we have causation. We do not have compliance. Compliance would mean paying back $10 million plus interest. Now, if this is what really went on with sovereign debt contracts, nobody would ever lend money to countries. All right? This is what's going on with the human rights treaties. And so we have to ask, okay, there's a causal effect, according to Beth, but how should we think about it? Countries are entering these treaties, but they're not complying with them. Right? They're not complying with them by terms. There's a causal effect. How should we decide whether the magnitude of the causal effect is enough for us to feel like these treaties are accomplishing their purposes? There's an interesting background that Beth alluded to in her remarks. In a way, her book, you might think of it as path-breaking or surprising or striking from a political science perspective, where there's a great deal of influence of realists who tend to think that laws and international institutions don't matter. So if that's the audience, she's falsifying their view, right? Which is dramatic. Of course, I suspect what they would say is, well, yeah, but these are small numbers. We're talking about, major influences. But nonetheless, she falsifies that view. I don't know whether realists still hold that view. I suspect some do. So that's an important accomplishment. From the lawyer's side, though, it's a little more complicated. I've always found it hard to figure out what exactly lawyers think about human rights treaties. I'm talking about academic lawyers. If there's the famous quote from Henkin, most states follow most of the principles of international law most of the time. I think Henkin understood this did not necessarily apply to human rights treaties. But if you thought it did, then Beth's work falsifies that, right? It's quite clear that states are nowhere near complying with human rights treaties most of the time, or even much of the time. Another thing I think here, what I say with Beth will disagree with, although maybe she might, so she certainly can respond if she wants. A final point about compliance, some of the dependent variables that Beth uses don't really have anything to do with compliance. I mean, take something like the number of girls in school or the ratio of women to men in public employment. In treaties like the positive rights type treaties like the ICESCR, it's not really clear what those treaties require. They often require you to kind of try to do something. So it's not clear what compliance means in that context. But if Beth is right, there's certainly a causal effect. Okay, so that's kind of a general point. Now, another point. What is the dependent variable? I mean, what do these coefficients actually tell us in these regressions? So this is hard. This was alluded to earlier. Take something like religious freedom. Okay, we're told that the variable is a dummy variable. That is, it's either 0, restrictive, the country's restrictive, or 1, the country is free. What does that mean? Restrictive means is defined to mean prohibitions on proselytizing, which, by the way, Beth does not object to on the last page of her book, prohibitions on clergy's political participation and or intimidation for religious beliefs and practices. Well, what does that mean? What does that mean? Okay, you get a 1 if you do, a 0 if you do those things, and a 1 if you don't do those things. Okay, and the graph, like all the graphs I mentioned to you, suggests that from 1981 to 2005, the states average like 0.7, okay? Which I guess means that something like around 7 countries get a 1. They're sort of free. And again, treaty ratifications in the meantime have increased a great deal. That's 0.08, statistically significant. I think, and here I'm going to plead at certain statistical ignorance, this is an OLS model, so I think it's just a percentage, right? So it means that the probability that a country is by, is that a lot or a little? What does that mean? Is that something we should be happy, or is it incredibly disappointing? We need some sort of method for evaluating the magnitudes. As Beth knows, as all empiricists know, statistical significance isn't all that we care about. We care about the magnitude of the coefficient. Okay, and a similar point can be made about other regressions. I wanted to say some things about report. I'll skip this. It's very interesting listening to what people were saying in the last panel. I didn't this political. There are lots of things, like suppose, for example, that these pass the treaty. Okay, they haven't ratified the treaty, we're mad at you, we're reporting like mad, and then they ratify, the agencies say, okay, you're trying a break, we're not going to cost a year or so, and definitely bias the outcomes. Effects. Human rights treaties, and human rights treaties, but she only actually less than a dozen treaty provisions. Okay. Provisions are there? I don't know. I haven't counted. I'd guess hundreds, certainly dozens, probably hundreds. All right. So we generalize from her about a few treaty to all of the treaty provisions. 2 minutes left. Terrific. Okay. Clear. Worry here is a substitutability worry. What if, I don't know how Beth select test. I think some are taken from the literature. She may have used other reasons. But and improve on the measurable outcomes from the areas that are less measurable. Okay. So religious freedom, that goes quality of to children resources from one situation. So I can't talk about 3 instrumental ratification. Say I was skeptical that they satisfy the conditions for. Let me just give one example. Ratification. It's perfectly possible regional pressure will directly influence and not do it on another country to enter a treaty. Okay, you can say similar points about the other ones, but I have negative 2 minutes left, so let me move on. Okay, correlation or causation. My worry is that what we've seen over the last 30 years is a lot of countries, transitional countries, that's a good thing, better probably because they're getting wealthier. As the Cold War ended, better, they enter into these treaties because they're saying to people, right, if that's a causal impact. Medically very sad, by the way, but I think it's a possible interpretation. Division of the population, this also worries. If you look at this going on, the graphs are, the lines are relatively flat. But if you divide things up, suddenly you get results for the well, sometimes it's the transitional country, sometimes it's the middle income country, sometimes it's the second state, sometimes moderately democratic. The worry here is that if you do your regressions and then you start searching for results, you can find an analogy would be, I invent a drug, I claim, We do the double-blind clinical tests for the FDA. Smarter, some people get dumber. But then evaluation, and I look for the blonde-haired people, the blue-eyed people, the tall people, younger, and I find out that the blue-eyed people actually do, and I say to the FDA, market the drug to the blue-eyed people. Okay, you can't do that, statistically invalid. Same concern is that states looking for something that's correlated with the improvement outcomes, you don't actually prove causality. I'll on my Darth Vader hat and talk of implications. What? Briefly. So Beth says treaties should be respected. That's her normative conclusion. How she gets odd in this. So assuming her results are correct, and I, despite basically think, yes, clear, right? Because they falsely believe in human rights treaties. Okay, then they should start with human rights treaties. Actually falsely believe that other states are complying with human rights treaties. And now they learn that they're not really doing all stop themselves. Concern here. Complying with a human rights treaty, I think Beth treats it as essentially costly. She recognizes the political costly. So let's take China has like 200 million people or more from the last 30 years, from style, poverty, reasonable. They did this while not complying with any human rights treaties, right? They had and they gave a reason. They said, look, we're concerned about poverty, not about human, okay? Should we criticize for not complying with the human rights treaties? One could say this is the greatest accomplishment of any state quite a long time in being human rights treaties. Now you might say, well, they could have complied with human rights treaties and raised all these people out of poverty, but what the counterfactual is, with two problems, and now I'll definitely stop. The first is that the police torture criminal suspects. People in rural areas have no access to medical treatment and schooling. The country has a certain budget. It's got to decide the budget entirely. Should it allocate them somehow? Do the human rights treaties provide an answer to this question? I would say they don't. Either the human rights treaties say you got to do both, which you might interpret them to say you've got to go after torture. It's not clear to me that it's better to eliminate torture. The result is that the children have adequate medical treatment and schooling. So it's not at all treaties permit states to make these trade-offs. It's going to be hard to criticize states simply making rights treaties permit. So with that, I will stop.
Not sure exactly what point the Darth Vader hat went on, but I can't possibly have everything in just. Let me to first of all the critique of what, and this is the sort of discussion of theory of the book, how saying that I don't enter a human right in the first place, ratify treaties, not. So I think one thing, this is why probably it's a 450-page book and not the whole thing, and to not understand post-World War II, to address human rights issues, is to sort of not understand the thing, not to say. So it seems to me that one thing to begin with, the degree of momentum that is behind this regime, historical to con. States need to decide, participate in this regime or not do so, at least in a different so. I don't think there are strong anticipating regime. I don't think there are. And I know this was said a couple, as far as I can tell. I actually did a little more empirical and tried to list of things we might consider rewards for ratifying human flows. I looked at flows, recently ratified human no bump at all in any of them. Looked at every U.S. discussion of international for a country, even any praise. Something that we could sort of statistically point, sort of mystery, shall we say. It has such a momentum, but I think to put context, does all of that. Now of the question of why comply with amendments. Now I'm gonna stuff is not. I want to pass over it. What the common law that there are some more costly than others, and that's associated areas, and that's associated kinds of way that both of those things are so countries and find an extraordinarily strong statistical effect. And Eric asks, well, why isn't that the case with all treaties? It turns out it is the case with lots of treaties. That common law countries do not enter into that rate as civil law countries do. I looked, for example, treaties, very, very different issue area, but found all to the common law. One is sort of this question of it's not possible to not, actually some states do. And one could ask, well, why don't they all? And I think that there is consistency, sort of process to system might a lot of others. It seems to me sort of can kind of easily carve out a certain kind of consistent limited access of these treaties when they permit the areas kinds of it seems to me. Graphs and the empirical graphs look. This should make us skeptical. We should be skeptical. You should be primed to this. book that would be between and control of tests and relations. So if you are primed to still find events to be pursued, added it all up and not just the regressions, but the case study. Well, then there's a little bit of sort of, I think, of every chapter which shows countries ratifying, and will perhaps sometimes measure. It will cause you to look very, very carefully and see if you believe. Up. Now, in terms of sort of trying to sort of explain the whole causal mechanism, there is, sort of the primary sort of work accommodate is the background would have been made anyway. And that is an article by Downs Rock, 1990s. Those who are interested in compliance with internet factuals don't have it's that change would not have been. And so, is to kind of address this to take some of the most, and the two most difficult cases, and the trials case. In those, Eric raises lies from your hundreds different, and sort of what these and how can we generalize the toughest treaty to trying to get compliance. As are some of the liberties, like I chose, also very, very to judge. And actually, the easy one was there is so much pre-compliance in that if a country be able to call to the International Covenant on Civil and Political Rights banning, they ratify. Why? It's public. It's public policy. States secretly, they don't secretly practice the death penalty, matter of public policy. Picking and choose terms of being can find effects in some of the most difficult cases. Possibility have stronger effects than we have generally given credit for. Now, I just one more minute. In terms of this worrying about slight evidence till you find a way to matter. This is what in putting boundaries. So about an drug affecting blue-eyed, find a chemical reason for that. Then it would be perfectly legitimately what Eric said. Precisely that drug, just as there is that maybe more affect certain ethnic groups than others, and by age groups, for example, as to why that one group and in others suspicious about slicing and dicing. Standing the conditions for the condition should have on out. There's nothing, in fact, wouldn't it be surprising if we found repressive countries to think, well, highly repressive. If there's no good, that's what we call putting on our theory. I'm going to leave it at really the last thing to think about is this very difficult question. And what do we encourage budgets? Actually, there's no clear question to this. I don't torture over. One interesting thing about some of them, getting assistance for understood to be budget on the right international cooperations. So, ask for help. Tough time deciding, go after the torture. It seems to me that it's not sure in which the international community, given the evidence, these national legal commitments like this can have positive, stringent budget constraint. So, but there's not a question to that whatsoever. So anyway, I think you also questions are ones, believe me, that was the most difficult part of the questions about reverse core. To have changed your anyway. I'm not a creator to take as wise consumer choices could. Today and suggestions that have been made along. I heard at least 4 or 5 suggestions for excellent research into the future. Very much appreciate the advice that yet needs to be done in the area.
Have at least, and then we'll have closing remarks.
Rights Watch, and I just Posner with his he or situation. How do you know that evolved on in a rights respecting way that in fact are outcomes? Is it really you have evidence?
Yeah, there's no way to know, and I famously argued that this type of trade-off is wrong and that requires demonstrations. So is a narrower whether trying to compel that country to adopt rights treaties will actually in that country. We don't really have any reason to think that China country is going to develop in the same way. So, historically, most countries that have democratic conditions, that's hardly.
China's, has contributed fair. And there's Siam also. I really take repression that we've to achieve those kinds. It has got its own set of has a reasonably high form of rights to be admired that the developed China went through. And so I guess I would say I'm sympathetic to that. And less sympathetic, but I wanted to make the point, though, being to have improved for so many people in China. Tricky trade-off. It has to decide increment of income, education. How do we make really very well to thinking about that as in the shutters for people? That's what's difficult there.
Here at NYU, we're really interested in sort of how to draft these. You notice was that areas these treaties seem to be so not, but do the way that the treaties are drafted, or is this purely of the treaty and there's not?
Well,
Do lawyers matter?
no experts, none. That reasonable variance, huge difference on compliance. And the big difference that is not because the ways is the probably different. I found, pretty strong in CPR and religious about religious network that is to demand religious to have association. To me is a good example of that. It'd be for fair trials. It's a very eels issue as we are criminals and they're in our society to sort of in some ways for criminals. Might be, for example, for freedom of difference of sanctuaries and observability. This is a little bit to observe something like the use of the death penalty, and not the way that a drafting expert.
I would be used so it's clear whether, and so something like the death penalty, but the language they substitute to something or more. So India has pretty good, but the border with extrajudicial. So the alternative is okay, and we're not going to specify. Then of course the concern whether the treaty or not.
There are those on the trade-off non-in treaties off to write are more willing to, like with part ICR, but not the you need to be cognizant trade-off for right is so cat of the treaties that I'm looking at.
And you mentioned in your response to historical momentum the human rights treaties, and I'm wondering if you think that has been sustained for the human rights enough to be effective years down the line as we emerge from historical context.
Turn my microphone on. Measure momentum in ratifications. If your team is stronger than it's ever been, I don't think that's measure. Do we make improvements in outcomes? That there's been some. So maybe we can success momentum. I should also say momentum during the some of the major powers were legalization of the too. It's not the probably, but some of the major in legal universal declaration came to creating. I think the same can Soviet Union and World War II. United Kingdom focused on the European global treaties of this area. So that there were from the newly countries as well, sort of be part of the coalition with a law lending greater attention to the legalization regime. I sort of sounded like inevitable. That's simply compared to in history. No doubt about that. And when it comes to the, but yes, I would say the moment. I sometimes feel like it's flagging in some ways. In some ways, I'm doing a little bit of work right now on the, and I've actually strong human laws into is not framed, but rather when it is free, that is linked. Interesting. There may be some more obligation, a little bit of resistance building up to the regime of this. So that's all.
To add Neil Moyne, maybe a of human rights argument, which is controversial 70s under the car. If you're interested in that argument.
It's a question, but benefits to countries because they say ought to countries can't live up to. People don't necessarily learn moral standards that I think from they are joining that sets firm.
So if I really think cruelty to animals, maybe I look a little.
Some benefits that are tangible. Been any more tangible world by ratifying. I can find. I haven't found anything. It's an intangible. So far, I've only looked at the United States. Maybe the EU is better at this. Praise documents of the United States. That what will be is that there are, but benefits it makes you feel good. If you see that's it. It could be there are benefits. Election is you've ratified. Maybe if your direction is seen, that is sort of yet to be seen. Documented. Now you find treaty for ratifying.
Speakers right now. A long day. Summarize where we were. It is absolute from where we started. That one of the things, precisely what occurred. Human rights treaties improve this room. I'm glad from the perspective of what it's worth, and even that on the face there has been from international humanitarian law, international civil aviation law, fine good, even aggression, law. In fact, this is on humanities law, which says, perhaps that is a state for others to prove or that the students from all of doing this, that every year roll in together this conversation to ask him what he frank in his after. I will also staying through the members of Herbert who is here and is an eternal.
Is this on? And on behalf of, we're going to get up, someone perhaps the most example of using color-coded, it was everything go to. Amanda was late. I'll take care of the work. Speaking of our appreciation, is this, but.
Oh, thank you. agenda. At these sorts of, I have a look. And moderators, we participation to that. Patients that you gave. Also, I would like to thank Rights and Global Justice. Many of you, and we thank them for. Also, thank international for months. Just myself, John Senior, Soda, wonderful student organization, Law Students for Human, especially Professor Alvarez. Thank you so much for all your help today. With the dean's office, with logistics. Thank you to of this great event, 17th, and also for taking time. Hope that you enjoyed it. Thank you.